Thank you very much, Shri Abhay Kumar Srivastava and very well said. It's all about now the technology and GST being a first side wherein the API-driven technology is being introduced. E-invoicing, India, e-invoicing is now being adopted by many other countries as well. And in fact, because I, being a founder of Cretum, also realized that consulting will not just be a end of the road. We'll have to evolve from the technology. So we created India's first technology on GST refund and other platforms by introducing technology. So I would like to now introduce for the presidential address by Hon'ble Mr. Justice Anil Kshetrapal, Judge High Court of Delhi, a distinguished jurist with an illustration career spanning nearly 4 decades. Justice Kshetrapal has made a significant contribution to constitutional and civil jurisprudence. His journey from respected senior advocate to the bench of Punjab and Haryana High Court and now the Delhi High Court reflects his unwavering commitment to justice, legal and excellence, and public service. So I would like to welcome Mr. Honorable Justice Anil Kshetrapal for the presidential address.
मित्र साहब ऊपर आइए प्लीज.
Come. Have seat. Dignitaries on the dais and off the dais, brothers and sisters. First of all, I must confess that I am a new student of taxation laws because I have just been allocated roster on 1st July. So don't expect much from me. But 3-4 issues I would like to highlight with whatever I have seen from 1 month's experience. First thing is that there is a very, very derogatory expression which is being used by certain social media and certain persons, which is within quotes tax terrorism, which according to me is it's not fair and proper. Everybody is doing his duty and trying to, because it's a new law, it's with us for the last 9 years only. It takes times to evolve. So such expression and harsh words should not be used by the. Second issue is with regard to input tax credit. According to me, this needs to be addressed immediately. Rather, we are late. Unless we tackle it right at this stage, it may result in going beyond our reach. Because once we are going for input tax credit and trying to use section 74, that there is fraud, there is fake forms, goodless invoices, all these things. We must segregate those who are involved and we must say those who are not involved. Those who are not involved should not be harassed, whereas those who are involved should not be spared. According to me, unless we are at the initial stage able to identify that these are the persons who are the real persons behind all these things, those who are involved must be punished in a severe manner, but those who are innocent, small businessmen who may not be aware of these things, they should not be harassed. This is first thing. Second thing which I have noticed is that there is a rampant use of section 83 of CGST Act, provisional attachment. According to me, this should be resorted to as a matter of last resort. Attaching a bank account of a businessman amounts to civil death. if it is to be resorted to, a note must be appended on the order while intimating the bank that its life is maximum for a period of 1 year. Because what I have seen is that writ petitions come to us after 2-3 years, and the financial institutions do not defreeze the account. Why can't, while the officers are passing order, they should specify it, and that is the mandate of the statute. It should be ensured that after 1 year, if no fresh order is passed, the assessee's bank accounts are defreezed. Third, now what I have seen is that for non-filing of returns, GST registration is cancelled. According to me, that should not be the first step. We should send notice. There may be a small businessman who may not be really aware of the technology. He may be having some issue. Unless it is a case of intentional negligence, effort must be made that cancellation of GST registration should not be resorted to. And if it has been resorted to, an application is filed for its revocation, the process should be smooth and streamlined, so that if he gives us a genuine explanation and pays the penalty, a human approach should be adopted to restore that GST registration, so as to enable him to continue his working. Fourth thing is, I think everybody must have now read that judgment of Punjab and Haryana High Court in Lakshmi Traders, uploading of notice on portal. According to me, the tax administrators are required to study that judgment, and if they find that some errors have been pointed out and some the judgment is correct, then it should be followed strictly, because that will reduce pendency to a great extent. Fifth is, what I find is that the orders are passed, very lengthy orders are passed, without even identifying the issues which are required education. I will only remind one thing, that under the civil law, it is mandatory that issues are culled out, issues are identified, and thereafter a judgment is given. Unless we start this practice, what we will be ending up is that 40-50 pages assessing authority will write, then first appeal 40-50 pages will be written, then tribunal will write 40-50 pages, and without even identifying what is the issue involved in the case. Brevity is the hallmark of all the judgments and thing. We should be concise in writing whatever we want to write, because unless we bring brevity in the orders, it will be very difficult to handle the situation. It will rather add burden, because if you have to draft a order of say 50 pages, you will need sufficient time. You can't dictate say 5 judgments in a day. If you want to dictate 5 judgments, you have to be precise. So my request would be that orders should be concise, identify the issues. Of course, necessary facts are required to be given. Whatever evidence has been collected, that has to be given. But there are ways and means where you can concise it. Maybe you can incorporate bullet points, you can incorporate tables. All these things can be done. And I will request everybody, if one can read judgments of Privy Council or judgments between 1960 to 1980, you will find 5-judge bench judgment written in 3 pages, and they are still holding That's how the cases should be decided. Last would be that investigations, analysis takes time. Of course, it is need of the hour. But with the advent of technology, with the help of all the facilities which are available, we can always speed up the investigation and conclude within a specified time. Because if the investigation continues and drags for years, the real threat goes. Unless we identify and punish who are guilty, who are perpetrators of the fraud, you will not get any effect if it is of ultimate order is passed after say 20 years or 5 years or 10 years. Last is, I would say, there is a offense under GST is cognizable. There is a power of arrest. That should be resorted to only in rare and exceptional cases. Because credibility of the institution is at stake, and we must make effort to avoid resorting to that power. Thank you very much for patiently listening. Thank you.